12:05 in the afternoon here on 90.3 FM on this Wednesday. And since it is Wednesday, that means it's time for Helping Seniors of Brevard, heard every Wednesday, 12 noon to 1 o'clock. And right now, let's check in with the host of Helping Seniors of Brevard and the executive director of the organization as well, known as Helping Seniors of Brevard. Here's Kerry Fink. Hi, Kerry.
Hey, John Harper, and thank you so much. It's always a pleasure to gather around the radio at lunchtime Wednesday. It's like our family tradition here on 90.3 FM, WEJF, and welcome also to our listeners online at WEJF.net. And so on behalf of our president and founder, Joe Steckler, and our entire Helping Seniors of Brevard crew, welcome. Gather your friends around the radio. We're going to have some really good information today because we are so fortunate to have in the studio with us a longtime friend of the Helping Seniors Radio and the Helping Seniors organization, none other than board-certified elder law attorney Bill Johnson. How are you today, Bill?
Good, Kerry. Good afternoon.
And I keep seeing that the kudos keeps rising for you because I was just commenting. I'm looking forward. There's a group here in town called the Space Coast Florida State Guardianship Association chapter, and now you are president of that for the next year.
Well, technically, I'm president of the Space Coast chapter of the Florida State Guardianship Association.
Well, that even sounds more impressive, right? But yeah, thank you for servicing. It's just it's a fact of how you give back into the community of your time, just like you take your time to volunteer and help us on the radio with good topics and things. And we've got a good topic today that we're going to talk about called guardianship. And in particular, we need to talk about it as it pertains to Florida. And so we're going to get into that in a minute. But we were sort of joshing before the show. I said, you know, people have asked us, I've gotten a lot of calls. They said, we couldn't get out to the American Muscle Car Museum, but you guys did give away the car. And the answer is, yes, we did. We pulled a winner. His name was David Odahowski. He's over in Orlando. He's a longtime Joe was explaining to the crowd there at the American Muscle Car Museum that back in Joe's Brevard Alzheimer's days, if you guys remember, Joe was the guy who got everything rolling with, now they call them the Joe's Clubs and all of that back in the day. Well, apparently the guy who won had supported Joe in all these endeavors over the years, and finally his ticket got pulled. And so I was asking Joe, I said, well, did he tell you which car he wants to go? Now, everybody who's been following the Helping Seniors car raffle for a while knows that there's become this big running thing called Team Dodge versus Team Chevy. And so we had the ladies from Hibiscus Court get together with the ladies from Seniors Helping Seniors, and they all just drove, I would almost say they just ran out AJ's cars out at Mark Pylock's test track there to try to figure out which car was better, and they kind of more or less all agreed it was really close. So what is our winner? So if you guys remember the history of this, in 2020, the winner chose the Chevrolet Camaro. And in 2019, the winner chose the Dodge Challenger. So the whole thing in the Team Dodge versus Team Chevy was, well, of course the winner is going to choose the Dodge or they're going to choose the Chevy. And what does the winner end up doing? He picks the Kia Sportage. So, and I was thinking, I would probably, the practical side of me might pick that. And I remember, Bill, you were saying you might be partial to the Mazda Miata, which was one of the choices too.
Correct, Gary.
And I remember John Harper talking about the Dodge Challenger. And so we were saying that it's going to be a whole interesting dynamic when we collect everybody to do the 2022 Helping Seniors car raffle. And we have Team Dodge versus Team Chevy again, how we're going to work the Kia into that. And so it goes. So anyway, folks, though, if you bought a ticket and you helped us out, really do want to thank you. We need all the help. We're a Florida nonprofit organization now in our 11th year of service here in Brevard County. Joe Steckler founded this after his successful development of the Brevard Alzheimer's. And I remember when I met him, Bill, and you've known him longer than I have. He came to me and said, Kerry, he said, I've learned through the very important work that we did there that seniors have more problems than just memory issues. They face a whole challenge of things that they have to work with and try to adapt to or work through just through the process of aging. And so he said, I really want to form an organization that does a lot of education and tries to help people formulate an aging plan and get as much as we can ahead of the curve on all that. And I know as an elder law attorney, you have to meet somebody for the first time and be thinking to yourself, I wish I'd met you 30 days before.
That happens quite a bit. A lot of what we do is crisis work.
Yeah.
Whereas a lot of it could have been prevented with proper planning.
And I think that's one of the talks about guardianship and why it's so important for us to talk about it, because I think it must happen quite frequently that somebody walks into your office and says, well, listen, mom just had a stroke or dad just had a stroke. They're in the hospital. They're not really responsive, and I got to figure out what to do.
That happens quite a bit.
And so they say, well, how do I do this? I got to get money out of the bank to pay the bills. I got to do this. I got to take care of that. The house mortgage is coming due. And people have these real life things.
Well, a lot of it boils down to whether or not they've done any pre-planning. Have they done a power of attorney to allow somebody to get access to their bank accounts and things like that, to pay the bills and pay the caregivers and that kind of stuff? And have they done a healthcare surrogate designation to name somebody to make their medical decisions in the event they're unable to give informed consent?
And I know that's one of the reasons why you're so serious about doing all the education in the community, because you, like helping seniors, are busy trying to get people to think a step ahead. I think you mentioned your daughter, who's an attorney, is giving a talk tomorrow over at one senior place. Is that right?
She is. She's talking around 4:00 on probate.
Yeah.
What it is, how it works, that kind of thing.
If somebody wants to get in on that, how do they do that?
They just need to show up at 4:00 at one senior place over on Spyglass Road.
Right. So, but the question with guardianship, and we come into that, most of us, we don't even know what that term means. I mean, maybe we've heard it, but, if you're the typical person and you're running your life at 80 miles an hour in all directions, and now somebody's sick and you're trying to figure out what to do, and maybe you didn't do the right planning, there's a whole lot of dimensions to this whole thing.
Well, there could be the people who didn't plan at all, and so subsequently they're stuck going to guardianship. There could be the people who planned, but planned inappropriately,
right.
or have defective planning and subsequently end up in guardianship. And then there could be the people who planned everything out perfectly, except the people they nominated to make their financial and healthcare decisions turned out to be inappropriate.
Wow. Well, a lot of dimensions there, but maybe could we back up a notch and just say, forgive us if you already know this, but because many people, this is the first exposure. What exactly is guardianship?
Well, guardianship's the process whereby we basically declare somebody incapacitated. The court does. And so we file a petition to determine capacity. At that point, the court will appoint a 3-member examining committee, a doctor and 2 other medical professionals, to go out and examine the person in person. And they run some tests and do physical examination, read the medical records, things like that. And then they report back to the court whether or not the person's partially, totally, or not at all incapacitated. And usually in Florida, not usually, in Florida, that is a means-tested determination. Can you manage your finances? Can you make your health care decision? Can you marry? Can you vote? Can you determine where you need to live, your social setting, have a driver's license, travel, all those what we call rights, and whether or not the person's capable of exercising those rights. And once we've had that determination whether or not somebody is partially or totally incapacitated, then we usually move on to the second step, which is the appointment of a guardian, unless there is a less restrictive alternative. Maybe they have a power of attorney or a healthcare surrogate and have nominated people in those documents to make their healthcare and financial decisions. And if those people are appropriate, then generally we don't have to have a guardian appointed. Sometimes those people are inappropriate. Mm-hmm. They're stealing from, mom or dad. They're exploiters, or they've neglected or abused the person, or they borrowed a lot of money, haven't paid it back, all kinds of, conflict of
Right.
interest kind of things. So sometimes those people, even though they have documents and named people, the people named in those documents are not appropriate. So then if that's the case, or they don't have any documents, we move on to the appointment of a guardian. And generally, at least one person will file a petition to be appointed as guardian. In Florida, you have to be over 18, able to carry out the duties of guardian. It can't have a felony conviction, and you cannot be a service provider to the individual, because obviously that's an inherent conflict of interest. And if we have just one petition and the person's found to be partially or totally incapacitated, well, then that person's nominated as a guardian. If we have multiple petitions, say we have a split in the family and several kids file petitions to be the guardian, then we have what's called a contested guardianship, and we have to have a trial to see who is the best person to be the guardian of the individual.
I'm going to come back on this a little bit more, but for sure, each time that you take another step with it, it sounds like more finances are involved as things get more complicated.
Right, and all this can be avoided with some proper planning and some, I would say, thoughtful planning. It's amazing to me how many people have nominated a certain child to do a certain task, like, say, manage finances, and they don't really know their own kid. And next thing you know, that kid's misappropriating all the person's money and things like that. And, there just seemed to be sometimes a bad judge of character.
So there's really two points about this, right? Because if somebody shows up in your office and let's just say that they really do have mom or dad's best interest at heart, but now mom or dad is incapacitated in a way that they can't really manage their own affairs, but the child who's trying to maybe do the right thing also now has no legal ability to help them on that level either, then you almost are saying, like, well, you have to have a guardianship.
You do, especially if there is some financial or healthcare decisions that need to be made.
And it's almost always more expensive to go that route than if you had done the pre-planning.
Correct. It's much more expensive.
And that's because you have court oversight for everything you do, right? Is that really the point?
That is true. The costs and fees and expenses of doing just a regular bare bones guardianship is about $10,000.
Wow.
So you're paying your attorney to file all the paperwork. You
Right.
got to pay the filing fees, which are alone over $600.
Wow.
Right there. You got to pay the examining committee. You got to pay the court-appointed attorney.
Wow.
And so you can see you got 3 medical professionals, 2 legal professionals,
Wow.
and the clerk of court has their hand out as well. So it's a large undertaking. There's a lot of paperwork. Once you become guardian, it's just not a free ride. You get to do whatever you want. You have to do reports to the court in the
Right.
form of inventories and accountings. You have to come up with care plans. So there is and those things get audited by the clerk of the court. So if your goal was to steal all your parents' money, you would not want to do a guardianship.
Well,
Because you have to, account and supply all this information to the clerk of the courts, and they audit it, and they will catch you. The number one tool for people who want to steal money from their parents is the durable power of attorney.
wow.
And that's why that document is probably one of the best documents for helping manage somebody's finances if they're incapacitated. But it's also one of the worst documents because if the person you've named happens to be an exploiter, you've just given the keys to your whole financial kingdom.
Well, and I think we've had this conversation before because, as you're hearing this, you're getting educated on guardianships as a general rule. But also, Bill, we've done so over the years, TV shows, radio shows, everything like that, really talking about the importance of planning ahead because what otherwise might be $10,000 in guardianship could be a very nominal fee to get things thought out and correctly set up going forward. But we've had this conversation before. Even people who may have thought they put together a proper plan and then moved to Florida from, a state up north or in the Midwest or something like that, because what you've explained in particular, I remember you telling us about this, is that the power of attorney in Florida can be quite different than what is in another state because it requires you to make very specific decisions, right?
Yes, it's basically an interpretation issue. In Florida, we specifically construe powers of attorney, meaning if you specifically don't give somebody a power, they don't have it. Where a lot of states, I'll give you two, Illinois and New York, have these statutory check the box format where you say, they can do anything with insurance. You just check a box. In Florida, that doesn't work. In Florida, you specifically have to spell out what they can do with your insurance. Can they take the cash value out? Can they transfer ownership? Can they change beneficiaries? You have to be much, much more specific. So the one-pagers from certain states, why they may be valid in Florida, don't work well in Florida.
And I've heard a lot of, I remember hearing a lot of people say that not only that even though you may have the correct form, then you're still jumping through hoops with the bank and things like that because they have all specific, they want it done this way or whatever.
Correct. And there are some banks that are notorious that just turn down powers of attorney every time.
So, but still, the lesson in the story is it really behooves you to get ahead of the curve and get this stuff done correctly. But let's suppose somebody shows up at the office and they haven't done this correctly on one of those three cases that you mentioned. Let's take the first one that maybe there was just no planning done. Now there's a catastrophic incident and people are trying to make sense of the next steps forward.
Well, usually they don't know what to do. They come in the office and say, Mom's had a stroke, Dad's already passed on, and Mom needs care. And we went to the bank trying to get into her account to pay for the care, but they won't talk to us because we don't have power of attorney. And then that's when you have to go into the whole speech. Well, it's a little too late to get it now because Mom's incapacitated. And you're going to have to basically go to court to get that authority to access Mom's accounts.
Wow, now when we talk about guardians, right? You as the person, let's say Mom didn't do that correctly, you could perhaps become named the guardian if you were willing to do that, right? Because you have family people who do guardianship because I guess probably because the planning wasn't in place. And they're just trying to step up to it. But then you also have professional guardians, which are people who manage.
Correct. So we actually have three layers.
Okay.
So we have the family members who step up to bat typically, and that could be the kids, it could be the other spouse, it could be the parents even, or even brothers and sisters, and they step up to bat and they file a petition to be the guardian. The other circumstance is where we have nobody but no other family or no family willing to step up sometimes. And they want to have a professional guardian do that. And those are people who are licensed through the or regulated through the Office of Public and Professional Guardianship. And they bill for their services as guardian, and generally get paid from the person's under guardianship's assets. And then the third case is you have somebody with no family and no assets, and that's when we have to usually call in the public guardian. There is a state of Florida public guardian, and different circuits have different public guardians. And those are the ones who step in and get paid by the state to manage the healthcare and financial decisions of the incapacitated person.
Wow, there's so many levels of complexity to this, and every time we have this conversation, it just always comes back and just is almost like a glaring neon sign saying, "Why don't you just get this stuff organized ahead of time?"
Exactly. And, especially if you are like a married couple and you don't have children,
Mm-hmm.
who is going to take over? Don't always assume your spouse is going to be there. I see a lot of plannings done where we have a husband and wife, they have no kids, and they've named each other on the documents, but there's no backup. And subsequently, that's when that usually gets caught up in a guardianship because one spouse may have dementia, and next thing you know, the other spouse has a stroke. And then both of them are incapacitated.
That was what I was going to ask you, because one thing that you said a minute ago actually surprised me. You said, well, we could be petitioning the court because, the son or the daughter, ought to be the guardian or whatever the case may be. But then you mentioned the spouse. And I thought, wouldn't that be almost automatic? And obviously the answer is no.
That brings us to the point. If you have a contested guardianship where more than one petition has been filed, the court usually considers four different criteria on who's going to be the guardian. One is, are they family? So it does not say, are they the spouse? It says family.
Wow.
So that puts the spouse on the same footing as the parents and the kids.
Wow.
And the brothers and sisters.
I see where this is going.
The second criteria is, do they have any special, business or educational background that would help in this particular guardianship? The third is, can they manage the finances involved? Is this a simple thing, or do we have millions and millions of dollars?
Mm-hmm.
And then the last criteria is, are they able to, carry out their duties and follow the law? So those are the four criteria that we're going to have on as to who is going to be the guardian. And sometimes we have a new spouse and kids from the prior marriage.
Right.
That all of a sudden, the one spouse becomes incapacitated and there were no documents spelling out who's going to do what, or there might have been documents saying my spouse is going to do this or my kids are going to do that, and then the other camp doesn't like the way they're doing it.
It's complicated.
And then next thing we end up in guardianship court.
Wow, that's all very complicated. We're going to come back on the other side of the mid-show break here and continue our conversation with elder law, board-certified elder law attorney Bill Johnson. And Bill, just before we go to the break, if people are hearing this and it's raising questions, or maybe better yet, they're going, I need to call Bill before I get into that. Real quick, what's the number to reach you at?
321-253-1667.
Great. And we'll see you for more Helping Seniors next.
It's 12:32 here on 90.3 FM. It's Wednesday, which means it's Helping Seniors of Brevard Day. Heard every Wednesday, 12 noon to 1 o'clock with your host, Kerry Fink. And right now, here is your host, Kerry Fink, the Executive Director of Helping Seniors of Brevard. Kerry?
Thank you, John Harper. And today here on 90.3 FM, WEJF, and welcome back listeners online too at WEJF.net. So we are having a great conversation with board-certified elder law attorney Bill Johnson. His law firm is called William A. Johnson, P.A., and we've been having a really robust discussion about guardianship, what it is, and maybe some ideas on why you want to consider avoiding it. And I asked you the question during the break. I said, is it? I would guess, is it a rule of thumb that if there aren't a lot of dollars attached to it, there's less likely to be contested guardianships?
And the answer is yes. If it's not a huge estate, usually there's not a huge fight.
You said you have a sign in your office, and I thought it was great.
Yeah, I have a sign that says money isn't everything, but it keeps the kids in touch.
But as we were having this conversation about guardianship, and specifically pre-planning would save maybe the necessity of having a guardianship. I was thinking if you have a lot of assets, it's probably very important that you want to set this up ahead of time so that your wishes are followed, as opposed to maybe arbitrarily something that would be happening through the guardianship proceedings. But I was actually thinking, maybe you don't have a lot of assets, and it really becomes even more important to do the pre-planning because the expense would sink everything else.
True, true. We get cases in where we need to get guardianship on people, and they can't afford the filing fee.
Right,
You
right.
know? So, yeah, that's very true. We have the reverse problem at times. A great example, I do Medicaid planning and helping people find ways to pay for long-term care. And for some of that, Medicaid, for example, generally counts cash value in life insurance, something that you don't normally think is an asset. Well, for Medicaid, you can only have $2,000 in assets,
Right.
excluding your house and car. And if you have a large amount of cash value in life insurance, that could prevent you from getting benefits.
Wow.
So in the last couple of years, I've done 2 or 3 guardianships just because nobody had any authority to take the cash value out of the life insurance to make the person eligible for Medicaid.
Wow.
And literally, if we didn't remove it, they wouldn't get benefits, and somebody would be on the hook for $10,000 a month. Not the incapacitated person, because they don't have any money. But we had to get the cash value out of there because it was over the asset limit.
Absolutely incredible. And that we've had this conversation so many times before that you see these commercials on TV. Oh, you can do this yourself. Just go to this online legal service, or worse yet, go down to an office supply store and get a form, and you can just take care of this real simple. But I hope, listener, as you're participating in today's broadcast, that you're getting a sense for this is something that you're best not to try on your own.
I get in my office all the time people that bring in documents that were done through online services, and some are better than others. But the one major problem I see is half the people don't follow the instructions. And by half, I mean 50%. Where it says you sign your name and 2 witnesses, the witnesses are not optional. And some people seem to think it's optional to have the witnesses there. If they just sign it, it's valid. And they don't read any of the instructions. And I would say, a good 50% of the documents I see that were done online were executed wrong. So they're void.
And what's horrifying about that, Bill? These were people who are smart enough to come in your office. And yet if you think about the people that may have done this and never consulted anybody, then they show up at a time of crisis and try to present documents that are going to be of no value at all.
And they think they're covered.
Right.
Yeah, they have this erroneous belief that they're covered, and then come to find out they're not.
Yeah, it's pretty scary when you think about that. I was saying as we were going into the mid-show break, we're talking with elder law attorney Bill Johnson, who is board certified and has been a longtime friend of the Helping Seniors. You and Joe Steckler, our president and founder, go way back. You helped Joe even in the days when he was building up Brevard Alzheimer's and getting Joe's clubs and everything going, and you've been a constant loyal friend to everything we've been doing with Helping Seniors since Joe started this back in 2011. But I was thinking, there's so many dynamics to this. And when you mentioned, we got into this conversation about guardianship, and I said, I would have assumed that the spouse of somebody would be the logical person to take care of the other spouse once some event happened. And you said, well, that can't always assume that because of, now what if it's contested and the kid says, I can do better than the new stepmom or something like that. And I was thinking about this because we were just recently fresh back from the Helping Seniors Travel Club cruise. We had this lovely cruise on the MSC Divina. We sailed out to their private island, MSC Ocean Cay, and then down to Mexico. And it was a group of almost the better part of 50 people. I think it was 44 total that were in our inaugural group. We all had a great time. And there was I believe she was about 85, and she has a background in show business, so she was a tremendous comedian. She was traveling with her husband, who she was proud to announce was her 8th husband. And so it was the running joke on the ship because this was her thing. So she said, I've been married 65 I think she said 65 years, but to 8 different husbands. And so everybody on the ship quickly did the math and was telling current husband, well, it seems like you only have a year left here, buddy. You're going to have to shape up. But I got to thinking, like, you must deal with a lot of blended families where stuff like this comes into question.
Correct. The statistics, I think, is like 50% of people over age 65 have a blended family.
Wow.
I mean, it's a huge number. So
yeah,
it's not uncommon. And then, the one thing that struck, I was on the website for the National Council on Aging, and I was trying to find the statistics on exploitation of all things. And they have them there. And 60% of exploitation done against an individual is done by that person's spouse or family.
Wow.
And I found I was kind of taken back because we don't normally talk about spouses exploiting other spouses, but it does happen. Especially in the case of an 8th marriage or something.
Well, yeah, and it was a beautiful group of people who were on the ship. And while this lady was certainly, if you do a statistical analysis, she was clearly the outlier, and she loved every minute of that. By the way, that was her personality. She was like the life of the party. But most of the people we talked to were really laughing about the fact that, this is my, it wasn't like they were just off doing things. It was like, we met several people on the cruise who had met their spouses that they were on the cruise with through grief counseling. Like, we lost our husband, she lost her husband, I lost my wife. So we met at grief counseling, and now we're together, and we've been together, 5 years or whatever. But I'm thinking, like, that could be, those guys are happy, but maybe not necessarily all the kids down the line are thinking, I don't know.
Yeah, and, a lot of times the kids do not get along with the new spouse for whatever reason.
Oh, yeah.
And so, and it depends on, what is the mental state of the person getting married again. Some people get married when they shouldn't be getting married.
Right.
They've got Alzheimer's disease and they're doing nuptials, and that's kind of a recipe for bad things to come.
A few weeks back, I had the privilege of attending the Florida State Guardianship Association conference. They had this big annual meeting over in Orlando, and one of the speakers was talking about the case of just what you're referring to about these blended families and people working, trying to work these things out. But it sure, every time I hear a story like this, it really brings back the point, like, a little pre-planning would make sure that what is going to happen is what you have in mind to happen, as opposed to somebody else's interpretation of what that means. And so when you talk about the financial aspect of guardianship versus the cost of pre-planning, it's like, why do we even put this stuff off, Bill?
Correct. I think part of the problem is that we don't have pensions anymore, and most 401ks are underfunded, and we're going to have a whole wave of poor seniors very shortly. Because we don't have a set retirement vehicle, for that. Between the economic collapse in 2007, then we have one 10 years earlier than that, the dot-com bubble, and then we had this COVID. Each of those times, people have dipped into their 401k instead of letting that stuff ride, to help out their kids,
right.
pay their mortgage because they got laid off, or things like that. And subsequently, 75% of 401ks are underfunded. And, we barely have any pensions in this country unless you work for the government or you're way up high in a corporation. So, a lot of people are counting on mom and dad's money for their retirement. Right. And then when you say, dad's gone and now mom's incapacitated, that's what gets everybody stirred up to fight about what happens to that money. And in the event mom got remarried, now you got a new spouse who's in the picture competing for that same pot of money. And I hate to put it in such frank terms, but on the outside looking in, a lot of times I think that's what the fights are all about.
I was thinking about, again, coming back to that the conference. I remember one of the instructors was talking about that one of the things in guardianship is one of the rights that you, I guess, are specifically trying to decide out of if you're part of an examining committee is the right to marry. And what I remember this particular speaker saying is that because I guess another part is about a contract, if you have the capacity to make a contract. And so he goes, well, what is marriage but a contract?
Correct. And there's a whole bunch of debate where people have been kept the right to marry, but had the right to contract taken away. And of course, then that just makes a whole mess of everything.
Yeah, it's pretty complicated because it seems like all you're trying to do at best in a guardianship, I mean, it has a very necessary purpose, but isn't it like you're trying to put Band-Aids on top of stuff to just try to keep it all moving forward, whereas a little bit of pre-planning might have prevented a lot of the expense, let alone the hair pulling that comes with all of it.
Well, my biggest gripe about guardianship is that once, dad's passed and mom becomes incapacitated and the kids don't get along, and then the kids want to show up in guardianship court and take 40 years of hate for each other out in the context of mom's guardianship.
You made
and mom may have not named or done the documents because she didn't want to name any one of the kids.
Wow. Yeah, you said a lot of times we talk about how ugly divorces can get sometimes. I guess it's probably the same.
Very much so. It can be quite litigious.
Wow. So, and as it's interesting because as an elder law attorney, on the one hand, I would think, well, that's probably good for the elder law attorneys because it means more billable hours. But yet you always are talking about, let's get this right beforehand so we don't have to spend all that money.
Correct. I mean, there's always the planning aspect of it and get the planning done so you're not one of these cases.
And you spend
and if you can't trust your kids, name somebody else.
Well, that's a good question. Do people ask you, say like, well, here's my situation. I have Johnny over here and he does this, and I have Susie over here who does that.
You can have like banks and brokerage firms act as your power of attorney. The problem is most of them won't get involved unless there are really significant assets.
Yeah.
And there are people out there, geriatric case managers that can do it for people who don't have kids or have kids that fight about everything. So there are groups out there that provide those services and can act on your behalf. But if you have a very, at each other's throat kind of family, I guess, you may not want to put one person in charge over another.
Well, and I think that's probably one of the reasons why the education component of all this is so important, because most of us don't even know how to think in these dimensions. We might know that little Johnny doesn't get along with little Freddie well, and so maybe we're cognizant of that, but we're not sure how to resolve that correctly if we're trying to make a go forward plan. But I guess that's part of the value of really taking the time to understand the ramifications of not making the plan, because that would scare you into going like, I need to make the plan.
Yeah, and sometimes the guardianship is advantageous over like a power of attorney in healthcare circuit. With a guardianship, the guardian of the property has to account to the court.
Yeah.
A power of attorney does not. They do whatever they want and they don't have to share any information with anybody and can do, at times it seems like whatever they want with mom or dad's money. So you can have some really bad outcomes, and sometimes it's preferable to have to make the person account to somebody for what they're spending the money on.
Yeah, I remember hearing over and over, if I heard it once, I probably heard it 100 times at that conference where they talk about the guardian's duty to use, what's it called, substitutive judgment?
Yeah, that's mainly on healthcare decisions. If you know what the person under guardianship's wishes were, then you should follow what their wishes are. And if you don't know what they are, then you should use what we call as best interest standard.
And so all these things, it's fascinating. And then, of course, on the financial side, you have that fiduciary duty because now you're requiring these reports and they get audited and all that. So really, if you're the person and you're thinking about your own situation, it would seem like a good first step would be to find a good opportunity to learn a little bit more about all this pre-need kind of stuff, and then make an appointment. So you do a lot of seminars and things like. Do you have any talks that are coming up where you're going to be talking a little bit more about this?
I just did a talk at one senior place about Medicaid and estate planning, and I usually rotate those every month. So I'm over there. If you call them up, it's one senior place, or go to their website. They have a listing of speakers.
And then you, too, over the years, have been generous with your time. You've done a lot of television shows with Joe and myself. And then also we archive every radio show. So I remember particularly like when you're mentioning just now about some of the things that we're talking about, there's shows on these topics. And if you go into the Helping Seniors website, YouTube page or Facebook page, and we'll Google for that, it'll be easy for you to find those broadcasts on those particular topics. But I would say better yet would be give a call to your office and talk about, what would be involved because really to get the best answer, you need to sit down and have the benefit of, here's my situation.
Right. And I know I've kind of painted a bleak picture about second marriages and stuff like that. For the most part, the people who come in and do the planning don't have any problems.
Well, if there's a connection, you think?
So the ones that blow up seem to be the very dysfunctional families.
Yeah. So if somebody wants to get a hold of, we're talking with elder law attorney Bill Johnson and board certified elder law attorney. How do they get in touch with your office?
They can call us at 321-253-1667.
And we're talking today, our topic is actually guardianship, and we've been talking about really a little bit about what it is. And I guess a question, I also remember hearing this at the recent State Guardianship Association conference, that apparently how guardianship works can be a little different from state to state. I remember...
I was going to mention that, like if you go north one state, that examining committee I talked about, that in Florida we have 3 people. Mm-hmm. If you go to Georgia, all you need is a letter from the doctor.
Wow.
That says the person's incapacitated.
Wow.
Yeah, so it's very much different. And Florida does take it quite seriously.
Yeah, because they were explaining, I think on the examining committee, one person is a medical doctor and 2 others are trained. And so they have this thing, and I remember the person who was doing the instruction on the examining committee said, this is very important that you understand you're more important than the judge in this. And here's what he said, and you can comment on it. He said, it's because if 2 of you say the person has capacity, doesn't matter what the judge says, it's done.
Over.
Yeah.
Yep.
Wow. So I guess the premise still is like, if guardianship is the only way, it is the only way. But if there's another route, is there a time ever that guardianship is a preferred route?
Well, like I said, if we wanted to make sure that all the finances were on the up and up and audited and things like that, that may be the preferable route.
Okay. So again, it's going to come down to each person's individual situation, and I guess that's one of the problems with, if you were to ever think about, well, I'll try this on my own, I'll try to look for an online service, or maybe I go to an attorney because they've helped me with real estate or something, and maybe ask them to help me with this elder law stuff. They don't really have the background to know the nuances of the questions to ask.
Correct. And there are a lot of documents we get done by general practitioners that just really aren't even up to snuff.
And that makes your job, well, again, these are the people who are at least smart enough to call you.
Right.
I can only imagine what happens to the ones who just show up with papers and they thought they were in good, and that's the problem, right? Because you thought you were in good shape until you found out you weren't.
Correct.
Wow. So if you wanted to sum up the advice that you would give to somebody as they are traveling down the road of life, and maybe starting to at least we talk about it, Joe calls it the aging plan, okay? So his point is, when we're kids, they say, what's your plan for life? What are you going to be when you grow up? Do you want to go to school? You want to be a doctor? You want to be a lawyer? What do you want to be when you grow up? And then when we're adults, what's your plan? Are you going to send your kids to college? Or where are you going to retire to? Are you going to do this? Are you going to do that? But we don't really talk in terms of an aging plan, which Joe's whole premise about the aging plan is much like we understand here in Florida having a hurricane plan. You hope the hurricane doesn't come here, but we're going to have talked about some things we would do if it is to come here. And I think that's the point of the aging plan. So if you're talking to somebody and trying to give them the benefit of your wisdom, because you've seen the good, the bad, and the ugly, I'm sure, how do you kind of capsulize it for somebody and say, don't let this happen to you. This is how you can get ahead of all of it.
Well, one is go see an elder law attorney or an estate planning attorney, get your documents done, get your decision makers in place well before you become incapacitated. That's the first step.
Mm-hmm. And it seems like another one is to review it at a certain point in time. We talked about it as people who move in from other states or people who had stuff done 20 years ago and now maybe people aren't living. Or
yeah, you should generally update it every 5 years, or if there's a major life event like a move, or somebody gets married, somebody dies, somebody's born, somebody gets divorced, that kind of thing.
Okay. So we've been talking with board-certified elder law attorney Bill Johnson with William A. Johnson, PA. You've got a good website at floridaelderlaw.net, right?
Correct.
And you're also known because you do that really good book that publishes each year in the Boomer Guide. And it's like, I don't know how to describe it exactly, but it's kind of like a primer on all these things you need to know.
Yeah, the Florida Long-Term Care and Nursing Home Answer Book.
So get a copy of the Boomer Guide if you can find one. That's a good tool that's in there that Bill and his office puts together. Again, you could give Bill's office a call directly. I think we were talking about your daughter is giving, who's an attorney too, in the elder law section, and she's giving a talk tomorrow at One Senior Place, 4 p.m. is I think what you said.
4 p.m., yep.
And if they want to call your office one more time, the phone number?
321-253-1667.
All right. Well, thank you, Bill Johnson. Next week on Helping Seniors Radio, we will be hearing from Dr. Lee Sheldon, another longtime friend of the Helping Seniors organization, and we'll have a lot of good information. Anytime that you want, you can find the information at helpingseniorsofbrevard.org. You can find us on Facebook or YouTube or right here on the radio next Wednesday at 12 noon. We'll see you then.